Good day, everyone. I am Emma R. Escames, and I am here to report the business failure under Chapter 23. Business failure can be considered from both economic and financial viewpoint. It is associated with firms that earn an inadequate return on investment. It involves questions of whether the failure is permanent or temporary. In financial viewpoint, the business is to be viewed in a technical insolvency, in a legal insolvency, or in a bankruptcy. The business is to be viewed in technical insolvency if it is unable to meet its current obligations as they come due, even the value of its assets exceeds the value of its liabilities. Legal insolvent if the record value of its asset is less than the recorded value of its liability. And the business is to be viewed in bankruptcy if it is unable to pay its debts and files a bankruptcy petition in accordance with the federal bankruptcy law. In economic viewpoint, the business failure is said to exist when a firm's revenues are not sufficient to cover the costs of doing business. So the failure of the business is determined whether permanent or temporary. When the failure of the business is permanent, the company should be probably liquidated. On the other hand, when the failure of the business is temporary, the company should probably attempt to deal the situation, especially if steps can be taken to speed the company's return to business success. An example of permanent business failure is when the business comes to an end. On the other hand, the example of temporary business failure is when the business strives to bring back to its success. Next is the business failure statistic. So, in table 23.6 of failure by age of business, we can see that about 30% of all companies that failed had been in business 3 years or less, and about 50% has been in business 5 years or less. Only about one quarter has been in business more than 10 years. In Table 23.7 is the list of some large bankruptcy filings through 2003. A number of these companies, such as the Federated Department Stores and Continental Airlines, have successfully reorganized themselves while in bankruptcy and have emerged to become profitable again. Other companies, such as A&R Rental, were liquidated and ceased to exist. For a number of these companies, the outcome is pending and may not known for some time. In case of Penn Central, the largest U.S. railroad, it took more than 8 years for the company to emerge from bankruptcy. So, causes of business failure. So, the important aspects of bankruptcy procedures involves what to do with a failing firm and if reorganization can be formulated. The firm is reorganized, otherwise it is liquidated. In Table 23.8, it shows the causes of business failure for companies that have failed. Although there are a number of reasons why business fails, most failures seems to be due at least in part to economic factors, financial causes, and lack of experience on the part of the owners of the business. So, alternatives of failing business. There are two alternatives that each business or firms can use. First, the business or the firm can attempt to resolve its difficulties with its creditors on a voluntary or informal basis. Second, it can petition the courts for assistance and formally declare bankruptcy. So, assignment is usually a trustee, not a schoolwork, who is probably one of the major creditors that is assigned the asset. The trustee then has a responsibility of selling the assets and distributing the proceeds in the best interest of the creditors. Informal alternatives, stretching its payables, turn to its bankers and request additional working capital loans, sale and leasebacks of its land and buildings, and restructuring the company's debts. In restructuring the company's debts, there are two ways. either extension or composition. If we say extension, it is where the failing company tries to reach an agreement with its creditors that will permit it to lengthen the time it has to meet its obligations, while composition is the firm's creditors accept some percentage amount less than their actual original claims, and the company is permitted to discharge its debt obligations by paying less than the full amounts owed. Under formal alternatives is the Bankruptcy Reform Act of 1978 states the basic mechanics of the bankruptcy procedure. Either the failing company or its unsecured creditors may initiate bankruptcy procedures by filing a claim in bankruptcy court. The terms can be voluntary or involuntary petition, wherein involuntary petition it is when a debtor company files for bankruptcy. It may be initiated by a group of 3 or more of the company's unsecured creditors that have aggregated claims of at least $500, while in involuntary petition, the unsecured creditors filing the claim must assert that the debtor company is not paying its present debts as they come due. After the initial bankruptcy petition has been filed, both the failing company and its creditors receive protection from the courts. The company itself is protected from any further actions on the part of the creditors while it attempts to work at a plan of reorganization having only 120 days. Normally, the troubled company is allowed to continue operations, but there are reasons that it will resort to further deterioration. The court can order the firm to cease operating. So continuation, prepackaged bankruptcy is a new development and alternative for firms considering bankruptcy. It must be agreed to by more than 50% of the creditors who hold at least two-thirds of the debt before filing for bankruptcy. And through this prepackaged bankruptcy, it can speed a firm's process in a few months compared to the many years traditional filings. The next topic is reorganization. It is similar to either composition or extension, where the Bankruptcy Court and the Securities and Exchange Commission review the plan of reorganization for fairness and feasibility. Fairness means the claims are to be settled in order of their priority, while feasibility is one that gives the business a good chance of re-establishing successful operations. So reorganization may also involve an extension of the debt maturities, which would help the company's cash flow, causing the debt's principal retirement to occur at later dates. And after the bankruptcy court and the SEC have reviewed the reorganizational plan, it is submitted to the firm creditors for approval. Creditors voted by class on reorganization plan where more than one plan is submitted for approval. The plan must be approved by a simple majority of 50% of the creditors in each class and by creditors representing two-thirds of the total amount of claims voting in each class. So the next topic is liquidation. If some reorganization is judged unfeasible, a legally declared bankrupt company may be liquidated. The term liquidation is the process of bringing a business to an end and distributing its assets to claimant. A bankrupt business is no longer existent once the liquidation process is complete. So as part of the liquidation, referee is appointed to handle the administrative aspects of the bankruptcy procedure. The referee arranges for a meeting for the creditors and they in turn select a trustee who liquidates the business and pays the creditors' claims according to the priority of claims. Absolute priority rule states that in general, secured debts are satisfied first from the sale of the secured assets and that all claims of creditors must be satisfied before any claims by stockholders. So the following list specifies the order of priority in which unsecured debts must be paid. So the first on the list is the expenses involved in the administration of the bankruptcy. Second, the business expenses incurred after an involuntary petition has been filed but before a trustee has been appointed. Third is the wages owed for services performed during the 3 months prior to the bankruptcy proceedings, not to exceed $2,000 per employee. Fourth is the certain unpaid contributions to employee benefit plans. Fifth is the certain customer layaways deposits, not to exceed $900 per individual. Sixth is the taxes owed to federal, state, and local government. Seven is the claim of general and unsecured creditors. Eighth is the preferred stockholders, where they receive an amount up to the par value or stated value of the preferred stock. So lastly is the common stockholders, where they share any remaining funds equally on a per share basis. So the reorganizational plan shown in table 23.9, about 40 senior creditors receive a combination of cash, debt securities, and 90% of the common stock of the reorganized company. The subordinated debts holders receive 7.5 of the common stock. The global's negative net worth of $116 million are virtually wiped out preferred and common shareholders. They receive only 2.5% of the common stock of the reorganized company, valued about $3.7 million, plus the warrants. To illustrate the absolute priority rule in a liquidation, consider the balance sheet prior to the liquidation of Filers Galore Incorporated, shown in Table 23.10. Suppose the total proceeds of the liquidation are $6.8 million and the distribution of this is shown in Table 23.11. The proceeds have been distributed in accordance with the absolute priority rule. Each general and unsecured creditors receive a settlement percentage of the funds owed after priority claims have been settled. So total assets are equal and balanced by their total liabilities and equities, having $12,500,000. As shown in Table 23.11, these priority claims are bankruptcy administration expenses, wages, and taxes owed. In addition, mortgage bondholders receive $1.5 million from the sale of secured asset. This leaves the mortgage bondholders as general creditors for the balance of their claim, which is $500,000. After these priority claims have been met, there is $4.25 million in asset left to meet the remaining creditors' claims of $8.5 million. Each general creditors receive 50% of the claim except banknotes. Because the subordinated debentures are subordinate to banknotes, the banknotes receive the proportionate claim of the subordinated holders, which is $1 million. In this case, in addition to the $1 million directly due the banknotes. Hence, because of the subordination provision in the debentures, the banknotes are paid off in full. So, thank you for listening. I hope you learned something from my report. And thank you. God bless. See you again.